I do it. This one?
Washington State of Michigan is now back in session. The Honorable Judge Simpson is on.
You may be seated. Court does call the case of the people versus Danina Combs.
Ashley Feltus for the people.
On this.
Thought it was
No, it's Ron. He just strolled in.
Is this Mr.
Miss Combs.
Smith?
Miss Combs
Oh, Ms. Combs?
from 9.
Yeah. Ron brought a bring on behalf of Ms. Combs.
This is the one. She appeared earlier.
And you asked for the medical
I
document.
asked for the medical documentation.
Yes, Your
I
Honor.
don't know if you provided it to the people. There is medical. Yes, you did.
I
I
reviewed
did.
it.
I did.
There is medical documentation here, so I will adjourn this out.
Thank you.
Probable cause conference will be adjourned to October.
Thank
I
you.
think she's able to go back to work, her activities increase, so I'll adjourn it to after that day.
Can she appear by Zoom?
Submit the form and we'll consider it.
Thank you.
Take care.
Bond will continue.
Thank you.
Court does call the case People versus Maurice Burgeon.
Ashley Feltus for the people.
Got my hands in front, behind my back. Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Burgeons, Your Honor. Starting to think that the smart bus is not so smart.
Oh,
So
no, it was.
I don't know what information you
He was
have.
not on that bus.
Okay. I mean, as
I
far,
don't think his wife was lying to it, or you,
okay,
but I don't think he was on that bus because the wife told you he got on the smart bus this morning.
she did.
That is probably true to the extent he needed to take one because actually he got to community corrections this morning.
Oh, okay.
Yeah,
And,
and that's where things went sideways.
oh,
Was he able to test this morning?
Well. Okay, that's a hard one to answer. Only because, yes, and it would have been okay had it been his own urine.
Technicalities of.
Yeah, so, yes,
so we had the money.
well, he tested,
And
well, somebody tested.
somebody did.
And that's why I wanted to see him today.
And Your Honor, as the court recalls, we had.
Apparently he carried it with him all the way on the smart bus.
Yes.
So,
That should be, there's props for that. I mean, props for that.
well,
That's,
crime carrying across county lines. Go ahead.
Your Honor, I know the court recalls, we were having we had 4 tests positive for THC and cocaine in late July, August. And then the court remanded the defendant and he missed 3, it sounds like, and then someone else is here this morning. So I would request that the court issue that bench warrant for his letter to appear here today in court. And I guess we'll see him when we see him.
I take it he's not in custody then, Your Honor, after
Oh,
testing?
he will be, but no, he's not.
Okay.
He's not in custody at this point. They did not take him in because they didn't have a warrant to take him in.
Understood.
Bench warrant will issue for defendant's failure to appear. I'm going to issue that bench warrant will be no bond given the circumstances in this case. That warrant will issue immediately.
Thank you, Your Honor. It may be interesting, I'll say that.
Well, and the reason I don't think his wife was lying is because he got on that smart bus this morning here.
Fair enough. Thank you.
Court calls the case, People versus Kenneth Moore.
Good afternoon, Your Honor. Dr. McPherson, requesting permission to practice pursuant.
Watch out, bowling. I gotta see you.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Feltus.
Thank you for keeping your voice up. Permission to practice is granted, Count.
I apologize about my big head, Your Honor. Brian Bowling,
Didn't
Assistant
say all
Public
that.
Defender on behalf of Mr. Moore. Just state your name for the record.
Kenneth Moore. All right.
Judge, I'm asking for an adjournment. Ms. Feltus and I are attempting to work on a discovery issue. So we need more
The
time.
discovery issue being,
We're looking into whether or not there's any video from the Pittsfield Township Police Department. Because I'd like to look at that.
probable cause conference will be adjourned October 9th, 2025. 9 a.m.
Thanks, Judge.
And we'll continue. Thank you, Mr. Moore. Court does call the case People versus Delonte Napier.
Good afternoon, Assistant Public Defender Davi Leba on behalf of Mr. Napier. Your Honor, if I could have one moment to get him from the hallway, he has a small child with him. Thank you.
Is.
I hope so.
What? What? I'm just. Don't any of these questions occur to anybody else?
Just don't say them out loud.
Oh, I get it. I'm getting better.
Mr. Napier, could you state your name, sir?
Delonte Napier. All right.
And Your Honor, I provided a green sheet to the court going to request an adjournment. I was just able to update contact information with Mr. Napier today.
Exactly. Probable cause conference will be adjourned to October 9th, 2025.
Thank you, Your Honor.
And bond will continue. Thank you, sir. And little one. Court calls the case, People versus Alexa Rushing. Rush in.
Brian Bowling on behalf of Ms. Russian, who should be on Zoom, hopefully. Ms. Russian, can you state your name for the record, please?
Sorry, Alexa Russian.
Thank you.
Judge, there was some confusion on my end as to what exactly the plea offer was here, me talking to Ms. Douglas to try to get something ironed out. We have it finalized at this point in time. I expect Ms. Russian to accept that deal. We just need to ultimately get the paperwork to the court and everything squared away. So, asking for an adjournment.
Probable cause conference will be adjourned October 9th, 2025. 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Thank you.
Court does call the case of the People versus Derek Shipman.
Dr. McPherson for the people.
Brian Bowling on behalf of Mr. Shipman.
Your name?
Derek Shipman.
Thank you.
Judge, I'm also asking for an adjournment in this matter. I'll just tell you that there's been some issue with us being able to work out getting Mr. Shipman to review the video in this matter remotely because he can never hear the audio. So he's coming into the office on Monday at 10:30 a.m. to do that.
To make sure to see that.
So we should be able to get this thing moving.
Okay.
Thanks. So just ask for another probable cause date.
Probable cause conference. We adjourn October 9th, 2025, 9 a.m.
Thank you, Judge.
Bond will continue.
Thank you.
Court calls case of the people versus, is it Uni Singletary?
Document Chair for the people.
Assistant Public Defender Davi Leba on behalf of Ms. Singletary, who appears via Zoom. Ms. Singletary, could you unmute and state your name, ma'am?
Uni Singletary.
I got it right. All right. All right, what are we doing?
Your Honor, we do have a plea agreement today. I provided the court
We do.
with a plea agreement and advice of rights. I did sign those on behalf of my client with their permission after reviewing both documents with her. Is that correct, Ms. Singletary?
Yes.
All right. Singletary, it's this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace, a 90-day misdemeanor. Upon your successful plea to that charge, count one would be dismissed. You're also agreeing to forfeit any interest you have in the taser currently in the possession of the EMU Police Department. And it's X through it. I want to make sure I understand this. There's an agreement to HIDA
Correct, Your Honor.
as part of this. That would be the court's full understanding of the agreement.
Yes.
Hold it. Who's yelling in her ear? Feltes, leave her alone. She's doing just fine.
Doing great.
All right. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. State your name again for the record, please.
Uni Singletary.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor. You can put your hand down. That's a misdemeanor punishable by up to 90 days incarceration and a $500 fine plus court cost. Do you understand that?
Yes.
All right. You seemed unsure about that. You understand the maximum penalties, ma'am?
Yes.
All right. I also have to advise you that, and it was not signed off on here, this is not my case, so that it would be, you'd be taking a plea before, you'd be taking the plea before me, but you would be sentenced before Judge Barr in the 14A2 District Court in the city of Ipsy. You understand that, ma'am?
Yes.
All right. And understanding all of that, do you still wish to plead guilty to this offense?
Yes.
To the charge of disturbing the peace, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You went through with your counsel an advice of rights form and they signed it on your behalf. Is that correct?
Yes.
Do you have any questions regarding any of the rights contained on that form?
No.
I'd ask you to note that under paragraph 5 are all of your trial rights. You understand that you'll be giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes. I do have a question.
Okay, I figured. All right, yes, go ahead. No, it's okay. What's the question?
Is it likely that I'll get the 90 days?
Okay.
I do hear the question.
Pardon?
I didn't hear the question, Your Honor.
Is it likely that she will do 90 days?
Ms. Singletary, we did discuss this earlier. Did you have additional questions on top of what we discussed earlier?
Okay, here's what I'm gonna do. I'm not gonna have that answered by you. I'm not gonna have the attorney-client
Of course.
conversation on the record. It's a good question, and it's a question, quite frankly, Ms. Singletary, that you should ask, get an answer, be reasonably assured of the answer. If I were sentencing you, I could pretty much tell you what the likelihood would be, but you're being sentenced before another judge. Okay? You all right?
Yes.
Your Honor, I just want to note for the record.
Okay, Ms. Singletary, what's wrong?
It's just all scary.
Okay. All right, listen. Here's what we're gonna do, okay? I'm gonna. Young lady, are you in school?
Yes.
You're at EMU?
Yes.
Okay, your only downfall is being up here near Ann Arbor and you come from Columbus. Cause I saw your address, okay?
Okay.
All right. What I want you to do is I don't want you to be worried about this, okay?
Okay.
There's a reason why they gave you this, and it seems to me that you also have a whole lot of questions about this, about things that may happen to you and what it all means, right?
Yes.
And those haven't, not that somebody didn't try, but those haven't been answered to your satisfaction, right?
Yes.
Okay, so here's what we're gonna do. I'm gonna adjourn this out a few weeks, okay? I'm gonna let you meet with your attorneys again, so that what you can do is then have more of a conversation and get all of your questions answered, okay?
Okay.
Okay, will that help you out?
Yes.
Okay. So do that, and the other thing I need you to understand, and you'll ask your attorneys about it, there's an agreement on this to Homes Useful Trainee Act, so you may want to, because you're probably worried about doing this and what's going to happen in your future, what's going to do whatever. So you might want to make sure that you have a full understanding of what that means. Okay? Because it can probably protect your future a little bit, which is why it's in this agreement.
Okay.
Your Honor, I just want to note for the record that I did discuss both the potential sentence in the matter.
I don't, counsel, sometimes it's not about us.
That is a correct
You
statement, Your Honor.
understand that?
Absolutely, Your
So
Honor.
I really don't need you to say anything.
Thank you.
It's about her. It's about her life. It's about a young lady trying to understand what may happen to her. You may have told her, you may have thought she would hear it, but she's probably maybe at that moment only hearing something else. So I don't need anything from you.
Thank you, Your Honor.
Ms. Singletary, I'm going to adjourn your probable cause conference to October 9th, okay?
Okay.
2025 at 9 a.m., but it'll probably be in a different block, but I'll adjourn it to that time. You meet with your attorneys, get all your questions answered, okay?
Okay.
All right, and then we'll see you on that day.
Thank you.
Ms. Singletary, you're more than welcome. You take care.
Your Honor, that is my last case of the day. Have a good afternoon.
Same. Mr. Brown?
Yes.
Valdez approach, please. Court has called the case of People versus Clacy Williams.
Good afternoon, Your Honor. Edward Lucas on behalf of Clacy Williams, who is approaching.
Shannon, are you leaving us? I saw you packing up. Have a great day. Yes. Your name, ma'am?
Clacy Williams.
All right. All right,
Thank
what
you,
are we
Your Honor. We're
doing?
asking, I submitted the form. I'm looking for an adjournment. I did just obtain discovery. I'm looking for more time to negotiate. Prosecutor.
Conference in this matter will be adjourned to October 9th, 2025, 9 a.m. Bond will continue. Thank you.
Okay, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Let's call the case of the People versus Joseph Smith.
Jennifer Douglas for the people.
Mr. Smith, Robert Smith.
Joseph Smith.
I'm sorry, Joseph Smith.
Yes,
I talked to him. Oh, here he
There
is.
he is. State your name, please, sir.
Joseph Smith.
Your Honor, we're requesting an adjournment. We're still trying to nail down the restitution issue.
The amount.
Yes.
Oh,
I think I put that on your, you got a green
yes,
sheet?
I got it.
Yes, sir.
But how much time is it going to take you to try to flush all that
Yeah.
out?
He's not, Robert Harrison. is the one. Joseph Smith.
Yes, another case.
Yes, he has a PC, he has a PE next week.
It's a continued preliminary examination. This is the case, I know Mr. Brown wasn't on the case last time, but Mr. Smith has two cases. We started the exam in the other case. It had to be continued because there was some additional discovery we had to get and turn over. And then
The affidavit.
yes, Your Honor. And
I
the bank
recall it
records.
now.
Okay.
Yeah, that was the one before me. Okay.
So Mr. Smith was not at the last date. You set this new PCC date. And I know that when we had set the continued date for next week, it was with the idea that this case was going to catch up with that case because we have there's a work in common.
You are absolutely, yes. Thank you for reminding me of that.
Then we'll set a PE on that same date for this case.
It's Tuesday and
Do you have the discovery on this case?
I have the discovery, but I was trying to nail down the restitution. A firm figure.
And so I don't know if I can have my elderly victim here Tuesday.
Right.
For this one. Because I wasn't sure whether or not Mr. Smith was going to be here today because he wasn't here last time. So I didn't want to have an elderly gentleman
Right.
show up for no reason.
That's why I said originally adjourned.
What if we did this? Because the other case, ideally, they were supposed to go together.
Yes, Your Honor.
So what I could do is we can adjourn the one on the 30th this Tuesday and kick that over to my next date, which is October 21st. And then we can set this one for exam on that same date. We can accomplish what we want to accomplish, but at a later period. Will
No
that work?
objection.
Yeah, that sounds great, Your Honor.
No objection.
All right. So
EE October 21st, 9 a.m.
yeah, I don't know where So preliminary examination in this matter, you would grab that other one and get that taken care of.
It's on the 23rd on this.
All right. It's on the 23rd.
Oh, 23rd. 23rd.
Oh, it's on the 23rd for exam. I'm sorry. I don't know why I was thinking that. Well, hold it, but I'm not, am I?
You gave it a special date.
I did. On purpose? Never mind. It was Douglas that must have convinced me of that. All right. So what I will do on this case is I'll set preliminary examination in person for October 21st 2025, 9 a.m. That's before me. Then we will take care of adjourning the other one to that same date. Bond in this case will continue.
So should we tell him now about Tuesday since he's here?
Oh, okay. Well, I thought maybe you understood it. Mr. Smith?
No, I think I understand it, Judge. So next Tuesday is getting adjourned
Yes.
until
And I'm
the
putting both
21st.
cases on October 21st.
Okay,
Okay, I think everybody was trying to do that before, so,
okay.
okay?
Thank
All
you.
right, thank you. Why'd you think he didn't understand? He was nodding along with me. Brown, just sit down. Court calls the case, People versus Emmanuel Sneed.
Jacqueline Gutierrez, please.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Sneed, who should be appearing via Zoom. He's not on?
Sneed? I don't see him.
Mr. Sneed's been appearing via Zoom. He lives in
Oh, yeah,
Florida.
yes, I'm here. I'm sorry, I'm trying to turn
Okay.
my,
Oh,
Emmanuel
okay,
Sneed.
Mr. Samson.
Okay, thank you. Your Honor, we are asking for an adjournment for some continued plea negotiations.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Where your invite indicates bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the People versus Bonnie St. John.
Assistant Public Defender Chelsea Vergils on behalf of Bonnie St. John. I understand that the court informed me she needed to be here in person. I informed her that my guess is that she was not able to make it here today. If she had been here, I have an order ready for a competency referral.
Okay, but she,
And there's a bond violation in this case, which is why I think the court said she had to be here in person, testify.
Absolutely.
And this is a possession case. I'm on a case in 14th District Court. She's already in warrant status and that for failing to appear a couple days ago in that court. I'm not sure what the competency issues are, but might be a factor here.
I can approach if the court would like more information.
no, at this point, irrespective of what those issues are, we have to get her to appear, right? So bench warrant will issue for defendant's failure to appear. At this point, given the violation, the nature of the charge, she hasn't appeared in other proceedings. I'm going to issue a no bond on her felony. And then we hopefully can get her and begin to deal with the issues.
Thank you.
Thank you. Court does call the case of People versus Kimberly Stampy.
Jacqueline Gutierrez, please.
Sampling, when you recollect, turn, could you please state your name for the record?
Kimberly Stampy.
Your Honor, we are asking for a brief adjournment in this matter for plea and negotiation purposes.
All right. Do you want to deal with the violation?
Yes.
You don't know what it is?
Oh.
You want my copy? And Mr. Allen? Do you want a paper copy? You can show her while you talk.
Yes, Your Honor.
Here.
May I approach?
Yes,
or
you may approach.
Mr. Allen said he would do it, Your Honor. Your Honor, my client has read the accusations against her. Your Honor, my client is going to ask for a hearing as it relates to these violations. She's saying that she hasn't been drinking.
I didn't know. I think I remember telling one time. One time.
Okay. So are you going to acknowledge that you do have a drink?
Yeah.
Drinking problem?
Yeah.
Okay, Your Honor, I've spoken to my client. I've explained to her the situation here today. My client admits that she has a drinking problem. She knows she has a drinking
No,
problem.
hold on. Are we changing?
Yes, she wants to change it.
So she just wants to stop lying?
Yes.
Oh, yeah.
She
okay.
wants to change it, Your Honor. I presented her with the information and let her know that with this type of information, it's better to be honest and truthful with yourself and the court. And she acknowledges that, Your
So
Honor.
you admit to the violations that you were consuming alcohol?
Yeah.
On September 10th and 11th?
Yeah.
Yeah, there's 2 different days. Your Honor, my client, she's going to acknowledge she does have a drinking problem. It's led to some pretty bad decisions in her life. She would like to stay out on bond. If perhaps we could get a scram tether on her to help with that, Your Honor.
Well, here's the only thing that the scram tether is gonna do. It's gonna tell me the exact same thing if she starts drinking that this one is, but quite frankly, a little bit later day.
Your Honor, my client's just, she's assured me that she will stop drinking. She'll go to meetings.
Didn't she already assure the court of that? So what makes me think that she's gonna tell the truth at this one?
Your Honor, I don't believe that my client fully understood the ramifications of what would happen if she did drink. I've let her know, and I'm assuming that.
So the court told her not to drink, particularly on a case where it's operating with a high BAC. And she didn't understand the ramifications of what would happen if she did.
Your Honor, my client has never been in trouble with the law before. And this is a very new process for her. And she is acknowledging again that she has a drinking problem. She's asking for the opportunity to prove to this court that she can be out and maintain sobriety while she's out.
Didn't make it a month. For the time that she was.
I understand that, Your Honor. And my client and I, we will have a very long conversation regarding perhaps AA, counseling, therapy, things of that nature, to help her overcome this severe problem
Well,
that she
you'll
does
know where
have.
she is to have that conversation. Defendant's bond is hereby ordered revoked. Defendant's remanded. I'll set this for probable cause conference on September 30th, 2025 at 9 a.m.
Thank you, Your Honor.
So was my bailiff.
I just gotta take the staples off. She can't take them with the staples. I'll come visit you, okay? And we'll try to put together.
This is gonna be another. You need.
You're good. I was making sure.
Court calls case People versus Michael Stone.
There's for the people.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Stone. Should also be appearing via Zoom.
Stone?
I'm here, Judge.
All right, state your name for the record, please.
Michael Stone.
Thank you, sir.
Your Honor, we are asking for an adjournment for some plea negotiations. I believe our office just received some documentation regarding treatment that he just completed. So
Got it.
I'd like to provide that. May I approach with the form?
You may. October 9th, 2025, 9 a.m. Thank you. Bond will continue.
Thank you, sir.
Thank you.
Yes, sir.
Case of the people versus Devon Sykes.
Dr. Gutierrez for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Sykes, who's also appearing via Zoom. Mr. Sykes, can you please state your name for the record? Please. Not. Your Honor, I spoke with him yesterday. This is
What a reaction.
sorry.
You usually don't have that reaction. Go ahead.
This is a case actually where the restitution has been paid and he was expecting a nollie pros to be filed. Before today, I think that there was an issue getting it released to the victim in the case. So we are waiting for that to happen, but the payment's been made. We're just waiting on that process. I would ask, considering
Hold on
that
a second. Who is the restitution paid to? The court?
it's been paid to the court. Yes.
And you can't, what? Right. Right, and you can't get it released.
I don't think that it said it can't be released. I think that the prosecutor's office was reaching out for the victim to go pick it up. And that hasn't taken
And that has
place,
not
my
happened yet.
Yes. And they are obviously want that released before they file the dismissal in the case.
Well, I mean, I get it from a technical standpoint, but why would we be, the court has the money. 14B has the money. They presumably will issue a check. The victim needs to go pick it up to be dismissed. If you dismiss this case now, it will be dismissed without prejudice. And the check will still be there. I'll even put on the order, release check to whomever you want me to release it to.
It should be on the order already that it's to be
Yes.
released to them. So I don't think their client can get the money back.
I mean, I'll adjourn it over. It just doesn't seem to me that adjourning it over accomplishes anything for us. I'll take any response you want from the prosecution.
Adjournment, please.
Are you serious? Are you an adjournment? This better be good if you're gonna come up here. I'm going to adjourn this to September 30th, or no, September 23rd. I got time on that date, right? I'm gonna set it for a special time, it's September 23rd, 2025, 9 a.m. You guys figure out how to get that guy his check so we can get this case off my docket.
Yes, sir.
Court calls the case of the people versus Randolph Taylor.
Andrew Bennett.
Again, on behalf of Mr. Taylor, but not with Your Honor. I'm asking for an adjournment.
I guess we're gonna do it this way and waste my time anyway. During this matter to September 30th, 2025, I won't issue the warrant. 9 a.m. Bond continues.
Okay, thank you.
Court calls the case, people versus Karish Turner.
Andrew Bennett.
This is the public defender, Brian Bowling. On behalf of Ms. Turner. Forgot my name.
Not with?
No, she should be on Zoom.
Ms. Turner?
I'm here.
Okay, state your name.
Carissa Turner.
Thank you.
Judge, I made a referral to the investigator in my office regarding this case. She's looking into getting some additional materials from the location of the incident. So I need a little time. I would ask for probable cause date.
Any objection? This matter will be adjourned to October 23rd. 2025, 9 a.m. Found continued.
Thank you, Your Honor.
Calls the case of the people versus Matthew Vermillion.
An assistant public defender, Jay Bellinger, on behalf of Mr. Vermaelen, Your Honor. Mr. Vermaelen, can you please state your name for the record? I believe he's appearing via Zoom, Your Honor.
Matthew Vermaelen.
Thank you, Your Honor. And we are just looking to set this for preliminary examination today. To my knowledge, to the best of my knowledge, discovery is complete. I understand this case was reauthorized, so we do have all the discovery.
People would have their witnesses available the 23rd.
Do our best, Your Honor.
Preliminary examination in person, September 23rd, 2025 at 9 a.m. before Judge Washington. 30th, I'm sorry, September.
Thank you, Your Honor.
My apologies.
And
that's 9 a.m. before Judge Washington.
Thank you, Your Honor. And I have let Mr. Vermaelen know that he does need to be in person for that as well.
It is an in-person hearing. You understand that, sir?
Yes, sir.
All right, fantastic. Thank you.
Thank you.
Court calls the case People versus Matthew Wallace.
Assistant Public Defender Chelsea Vergils on behalf of Matthew Wallace, who I did speak to yesterday but have not seen today.
Matthew Wallace. He's already got bench warrants. Already got bench warrants out with no bail.
Yes, sir.
On all three.
Just two.
Hang on a second, counsel. I'm just trying to sort this out. I have communicated bench warrant on all three. It looks like. We'll double check that. So I will lead the bench warrants that are currently they're outstanding. He has a bench warrant for no bond on this.
Okay, I understand, Your Honor.
House case People versus Doris Williams.
Assistant Public Defender Hannah Apple appearing on behalf of Miss Williams, who should be appearing via Zoom.
Ms. Williams?
Yes, sir.
All right. Thank you. Can you state your name for the record, please?
Doris Williams.
Your Honor, we're asking for an adjournment. There's some outstanding video discovery CCTV, as well as I did propose a plea resolution in this case, so could have a adjourn date.
I'll adjourn this matter to October 16th, 2025.
Yeah.
9 a.m. Bond will continue.
Thank you. Thank you.
Court calls case People versus Damian Williamson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williamson, who's approaching now. Mr. Williamson, will you state your name for the record?
Damian Williamson.
Thank you. Your Honor, we are asking for an adjournment for some continued plea negotiations, and I also am asking to readdress bond. Same request as the last court date. If the court recalls, I asked, this is a single count of RNO. He has a no contact in order with Karina Stevenson, who is the mother of his child. She's not a complaining witness in this case. The people represented to the court that the reason that request was made is because there was a January report that was made that had still not been sworn to on the last court date.
Has it been sworn to already?
Your Honor, I reached out to YPD, reached out the same day as the last time I reached out.
It seems like a yes or no.
I don't know. They claim that they did, but I
Okay.
checked my court. I don't see it in my court. YPD claims they swore to it on September 5th, but I don't see it in the system.
And
I checked my court yesterday.
you
and I
just
don't-
want no non-consensual contact.
Correct.
Prepare me an order, so ordered.
Thank you.
I will adjourn probable cause in this case. I will adjourn it to October 9th, 2025, 9 a.m. Bond will continue with that adjustment.
Judge, if he may briefly,
I just want to apologize for last time. I just walked off. I just want to apologize man to man. That's all I want to say.
he was frustrated at the circumstances.
I understood. I appreciate it.
Thank you.
I appreciate the apology.
Okay.
Thank you.
Have a good one, sir. Your Honor.
That's it for that block. Recess.
All right. Maybe see you. All right. 14A District Court was coming Western North State of Michigan is now back in session. The Honorable Judge Jason.
You may be seated. Court recalls case People versus Dustin Duncan.
Brian Bowling on behalf of Mr. Duncan, Your Honor, approaching. Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name?
There's a bond by.
Yeah, no, I see it. I got it. Don't worry. Is it 25? Well, you see the violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date.
But
and then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote a picket?
I understand all of that, but my other problem is that given the other sort of mistest? I mean, what about on, you say the twisted T on the 13th? What about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and Newman Country.
I just said that, but you're
Oh,
welcome to
no,
say it if you'd
no.
like to.
No, I didn't. I start talking. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I
So
was.
I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. And you really, quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether pending getting into an inpatient treatment facility?
It's the reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bond is.
Thank you. I'm sorry, you said September 30th? 30th. Thank you, Judge.
Court does call the case People versus Jeremiah.
Ready, Your Honor. Andrew Vance, please.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Dillon, who stands to my right side. Please state your name.
Jeremiah Dillon. All right. I have before me a plea form that indicates the defendant's going to be pleading guilty to 3 different charges. And the first charge is operating while intoxicated with an occupant less than 16, the 1-year offense. Operating 2 counts of that.
Those are on the original complaint, 2 and 3. So it's really count 1 that's being reduced to the.
I see that.
Okay.
Also indicates that he's pleading guilty to 2 charges of operating while intoxicated, occupant less than 16, and then controlled substance use of cocaine, all 1-year offenses. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's entire understanding of that.
That is defense's understanding as well, Your Honor.
Counsel approach. Going to pass this matter. All right, talk to your attorney.
All right, thank you, sir.
All right, thank you. Court does call the case People versus Randall Jolly.
Andrew Vance for the people.
Your Honor, good afternoon. Mark Ellis representing Mr. Jolly, who stands to my right. Please tell the judge your name.
Randall Jolly.
All right, go ahead.
Your Honor, we have been offered a plea bargain. We wish to take advantage. We have signed the forms.
But does he have a medical marijuana card?
Yes.
All right. And the other, why didn't we get another regulation report? Because I think we went through this before.
Yeah, it's actually a progress report. He has a prescription for exactly that drug. So
I know what it is. His healthcare provider hasn't provided anything.
Yes, he has sought that and it hasn't been given to him yet. He has asked for that. And we apologize.
Well, but my problem is, he's telling me that's what he's on. He's telling me that, but I
Yes.
don't have anything from a healthcare provider.
He actually had a prescription bottle with him every time he's ever tested. He had one in court with him last time.
Okay, let me try this again. They asked for documentation from the healthcare provider.
Yes.
We don't have it.
Yes.
So I'm not taking his plea. Or I find that he's in violation because it's there. It sounds like to me what you're indicating is that's not his fault. They haven't provided it. But I have no idea whether or not this is even true. What he is indicating is true, which is why Community Corrections is asking for the healthcare provider information.
Maybe we can adjourn for the plea and.
Can he get it? How fast can he get?
I'm sorry, I do not know. I do know that sometimes asking your doctor for a note doesn't mean they give it to you.
Well, then we've got a problem. I mean, he can actually he can get some of that information potentially from his pharmacist in terms of whether or not there's a valid prescription. I mean, they want information from medical care provider that he indeed has a prescription.
Okay.
That has not been given. It wasn't here entirely at the last hearing and I didn't remand him. But
We
now I'm
appreciate that.
here. I still don't have it. I still have what looked like dirty tests. You're telling me that he's got a doctor's prescription. I just don't have it.
My understanding is the only way you get a prescription bottle that says a drug on it is you go to the pharmacy and they give it to you.
Give me a computer, I'll make you one. Or one that at least looks like it.
We'd be happy to supply if a note from his pharmacy is adequate to the court.
Well, something that just indicates that there's a prescription. That is a valid prescription for this narcotic.
Take a bottle. Oh, a bottle can be plagiarized, so to speak.
And I will then, this probable cause conference, how long will it take you to do it? Can you get it done by the 30th?
Absolutely, yes, sir.
I'll adjourn this matter out to September 30th, 2025 at 9 a.m. Correct? 30th. No, you can't do. Well, yes, I can. At 9 a.m. That's a split day.
That is fine, Your Honor.
Yes.
Thank you.
Okay. Bond will continue. Thank you.
Your Honor, thank you.
Thank you. Court does call the case of People versus Cyrus Wigbright.
John Minnick on
Cyrus
behalf.
Wigbright. Sir, please state your appearance.
Oh, Cyrus McBride.
All right. What are we doing on this case?
Exam waiver.
Sir, you're waiving your right to have a preliminary examination?
Yes, that's correct, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, I do.
You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, I understand.
People also waive their right?
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on all 6 counts. Mr. Minnick, you acknowledge receipt of the information, waive its reading, and your client stands mute?
That is correct.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial will be set for
November 18th at 1:30 with Judge Conkey.
November 18, 2025, 1:30 before Judge Conkey.
Thank you.
Thank you.
Robert, may I approach and sign the information?
Yes, you may. Court calls the case, People versus James Belleville.
Edward Drukas for James Belleville.
Mr. Belleville, state your name, please.
James Belleville, Your Honor.
All right. All right. You're requesting an adjournment. Is this an issue? Restitution money needs to be paid?
Yeah, it was paid yesterday. Anali's going to follow.
That's correct, Your Honor. It's unfortunately a bit of a Groundhog's Day situation. I just received via text confirmation from Mr. Drukas that it has been paid. I am going to call 14 the district court and make sure that gets, I don't feel like it needs to be adjourned. I will submit a nollie,
All right.
hopefully tomorrow.
The other thing is, the order, does the order read upon its payment that upon the money being deposited, that it would be paid over to the victim? Because that's how the other cases have read.
That I don't know.
Okay.
I'm covering this case for Ms. and who's covering for Ms. Zenda. So
Got it.
I will confirm what the order says and make sure that.
If you prepare a nollie that indicates that the case is dismissed, but money needs to be paid, and put that information in, I'll sign that one.
Okay.
All right.
Thank you.
This case is dismissed.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Myron Barnes.
Sherilyn Foster Tucker on behalf of Myron Barnes.
Myron Barnes.
Take your hands out of your pockets.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of use of cocaine, 1-year offense. Upon a successful plea to that charge, that's an added count 3, I think. And
Yes.
then counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, true self you got?
Yes.
State your name.
Myron Barnes. Do you have an advisory form?
Yes, I.
You have one you want to give to me, or? All right, I got it. Okay, it's okay. All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that, sir? Yes. All right. You also understand, sir, that while I'm taking a plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir? Yes. All right. Still wish to plead guilty? Yes. And to that charge, how do you plead? Guilty. And you understand by pleading guilty, you'll not have a trial of any kind? Yeah. You signed an advice of rights form, is that correct? Yeah. Any questions regarding those rights? Oh, all right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yeah. Are you on probation? No. On parole? No. Anybody promise you anything other than what's been stated here today on the record? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes. Of your own free will? Yes. And because you believe that you're guilty? Yeah, okay. On February 16, 2025, at the location of Packard near Fernwood in the city of Ann Arbor, Washington County, state of Michigan, did you have cocaine in your possession? Yes. Had you used it? Yes. Did you know what you were using was cocaine? Yeah. I have to ask, sir. All right. But you did know that. All right. Okay. Sir, I do have to advise you that if I accept your plea and you commit between this date and the time of your sentencing misconduct as defined by the Michigan court rules, any sentence evaluation, the judge would no longer be bound by and you could not withdraw your plea. You understand that, sir? Yes. Is counsel aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
October 10th at 8:30.
October 10th,
Yes.
2025, 8:30 before Judge Perry. Okay. Okay. Bond will continue. Thank you, sir. All right,
Thank you, Your Honor.
What you're using? Yeah. Of course I knew. Across the case of the people versus, is it Joyua Wallace Taylor? I messed that up and if you come up here and yell at me, my feelings will get hurt, and that's not a good thing.
Definitely fair for the people.
Sherilyn Foster Tucker on behalf of Joya Wallace Taylor.
Joya Wallace Taylor.
I'm just gonna call her Joy. I'm gonna go through the last 2 letters. It confuses me. All right, what are we doing on this case?
Your Honor, we're just requesting an adjournment for some continued discussions.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court calls the case, People versus Adrian German.
Good afternoon, Your Honor. Hassan Bazi, P78448 on behalf of Mr. German. Mr. German, can you state your name for the record, please?
Yes, Adrian German.
Thank you, sir.
Freeman Cook, the people standing in for Andrew Banks.
All right. And I have a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading no contest to the charge of welfare fraud, failure to inform less than $500, the 90-day offense. Upon his successful plea to that charge, count 1 would be dismissed. The defendant is agreeing to repay restitution in full in the amount of $10,208 that the prosecutor will recommend that there's no objection to a dismissal via the prosecutor's deferred program if restitution is repaid in full and any and other orders or conditions of sentencing are satisfied. That is the court's full understanding of the agreement. I want to make sure, because the sentencing judge waiver box is checked, but it looks like it's scratched out, but you mean to check the sentencing box waiver, is that correct? Is that correct, counsel?
Oh, yes, Your Honor. Yes.
Okay. I just want to make sure because
I'm sorry. I thought you were talking to the prosecutor.
Not unless I have to. Anyway, no.
I don't blame you. I don't blame you. No, I'm
all
joking.
right. All right. I know Mr. Cook keeps you. All right. That's the court's full understanding of the agreement. All right. Mr. German, can you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for me, please.
Adrian German.
All right. You can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of welfare fraud, failure to inform. That is a misdemeanor punishable by up to 90 days and $500 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes.
All right, two things about it I have to make sure that you understand. First thing is it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
I also will inform you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead no contest?
Yes.
Basis for the no contest plea, counsel?
Judge, civil liability.
All right. Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yeah.
Okay. Sir, I've seen you. We're going to shut your video down to get more bandwidth so I can hear your answers, okay? Can we shut it? All right. Mr. German, can you still hear me?
Yes, I can hear you, sir.
Okay, now that's much better for us. All right, and you're doing this voluntarily and of your own free will, is that correct?
Yes, Your Honor.
All right, the court has been provided and has reviewed the investigative report of the State of Michigan Department of Health and Human Services, Office of Inspector General, for their case number I-23-11-11-7670. Any objection to the court having reviewed that report?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Mr. German, I do have to apprise you that if you commit misconduct between the time I accept your plea and the time of sentencing, that any sentence agreement or any evaluation by the court no longer would be bound by. You understand that, sir?
Yes, Your Honor.
And also that you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Nothing, people.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea to discharge?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 28th at 9 a.m.
October 28th, 2025, 9 a.m. before Judge Freshour.
Would that be on Zoom, Your Honor?
Pardon?
Would that be on Zoom?
You'll have to contact her chambers and determine how they're handling it.
Okay,
All right,
and then
sir.
the pre-sentencing report, is there anywhere he has to call for the pre-sentencing report or anything?
He does. We'll ship you an email with the numbers for their probation, so you have it, counsel.
Thank you, Your Honor. Have a good day to you and your staff. Thank you.
All right, thank you.
Thank you.
Bond continued.
I have this for your recall whenever
Hello.
you're ready.
Okay, got it. Court does call the case People versus Desiree Gray.
For Douglas, for the people?
Good afternoon, Your Honor.
Hello.
Robert Ellman with it on behalf of Ms. Gray, who is present over Zoom. Ms. Gray, can you please state your name for the record?
Desiree Gray.
Your Honor, you should have a green sheet in your file
I was recently appointed to this matter and I need some time to go through discovery as well as get some records from Miss Gray and talk to the prosecution as well.
Probable cause will be adjourned October 9th, 2025, 9 a.m. or if your invite indicates bond will continue.
Your Honor, may I address bond very briefly?
She's out.
I'm very happy.
To lock her up?
No, Your Honor,
No,
she
go
is,
ahead.
she is
What's your
very
argument?
grateful to be out. We just asking for one minor change. There
Okay.
is, in her bond, a no contact listed with a, Mr. Robert Lewis, who is,
Hang on a second. With Robert Lewis?
yes,
Okay, I got it. Yep.
who is, I believe her boyfriend and also I guess, co-defendant in these charges, though it's a separate case. However, Your Honor, I have some positive news I'd like to share with you. That Miss Gray is at Bear River. She's completed her inpatient stay at Bear River. She's now doing outpatient there. She's very successful. She's also working. One of the reasons I'm asking for this to be lifted is that Mr. Lewis is also doing inpatient right now at Bear River. And he, I believe, is set to be graduating the inpatient portion of Bear River in the next week or two. And at that point, there is potential for them to be in the same outpatient classes, for lack of a better phrase. And I would just like them to have contact so they can go through that together. And as well as there's also no kind of scheduling issues in terms of those classes or meetings.
Sponsoring the people.
Your Honor, I don't have an objection for them to have contact if they end up being scheduled in the same group. The people's concern was that the charged conduct could continue if there was contact, if not a concern about assaultive behavior or anything like that. So, Your Honor, in these circumstances, the people wouldn't have objection.
Well, I don't know that I'm gonna change the bond. Why would I change the bond? Just why wouldn't I just indicate that if they happen to end up in the same group, that there will be no violation?
I guess so that they could have contact outside of group as well, Your Honor.
So it's really not so much about group. It's more
It
about-
is. That is my main concern, but I'm asking you to change it in
Well,
its
what is it
entirety.
for though? If it's so that they can have contact with each other, then just say that that's what we're talking about. If it's so that they can go to group together, that might become a different circumstance.
And I guess, Your Honor, I think maybe it's both. I think the group is the more pressing matter because I don't want Miss Gray to have to leave group if Mr. Lewis is there or anything like that. So that for me is the more pressing matter. I know they'd
She
like,
wants to be with her boyfriend.
yes,
Is that what it is?
that's, yes,
Almonds, just say it.
Your Honor, she would love to be with
Is
her
that-
boyfriend.
Ma'am,
Yes, Your Honor.
is that why you want contact?
Yes, Your Honor.
Your Honor, so the people's understanding was that this was so that there wouldn't be any problem with them being scheduled for treatment or rehab.
I know.
I didn't know it was just to hang out together, because that is what the people object to. Because the allegation is that the defendant and her boyfriend were engaging in multi-county drug sales. And so I would have objections if people happen to end up in the same rehab treatment group, because that would be a positive. But this, just to spend time together is exactly the kind of thing that people had been concerned about in this case.
And Your Honor, I apologize. I thought I had, apparently I'm not being very clear to the people or to Your Honor, so I apologize. My ask is for both. My main concern though is the rehab. So if you are not inclined to.
I get it, and you kind of stated that, but I needed to flush it out because I think those are two different things. If they ended up in the same treatment together, it would be doubtful that I would violate them if that's how they just got assigned. Right? If, however, it becomes an issue of, as Douglas said, just them being permitted to hang out with each other, the people have an objection to it. And I would have some concerns because both of them have ended up where they have ended up for a reason. And probably part of that is a relationship that is not helpful for one another.
And I understand those concerns very well, Your Honor. And so I would ask that at the very least, if they could be allowed to attend treatment if they end up in the same treatment.
Yeah, if they end up in the same treatment, then I'll deal with that when it happens.
Fair enough, Your Honor. Thank you.
There's a violation that's filed. Your motion for bond modification is denied. Bond will continue as such. Thank you.
Thank you, Your Honor. I'll be in touch soon, Ms. Gray.
Thank you.
Court calls the case of the people versus Michael Laster.
Andrew Banis for the people.
You're not done with me yet, Your Honor. Robert Ellman with it on behalf of Mr. Laster, who's approaching.
Your name, sir?
Michael Laster.
Thank you.
Your Honor, you should have a green sheet in your file on this one as well. So I am in talks with Mr. Banis about resolving this matter at the district court level. However, we'd like to entertain the idea of Mr. Laster entering into sobriety court. He's, however, an out-of-county resident.
He's out what county?
Wayne County.
Wayne County.
And I've contacted Romulus District Court, who said we could transfer him. However, I just got that information and I need to flush that out and get him screened as well.
Get him screened and get him, okay.
Yeah.
I'll adjourn this out. Let me give you some additional time to try to get that done, if that's what he's looking to try to do.
Thank you, Your Honor.
Probable cause, I'll adjourn it to October 23rd. Okay, let that process take place. All right, Mr. Lester.
Thank you, Your Honor. I appreciate it.
2025, 9 a.m. All right, bond will continue. Thank you, sir.
Thank you.
Have a great rest of the day, Your Honor.
You do the same.
Mr. Laster, I'll be in touch soon.
Court calls the case, people versus Mayas Sharif.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Representing Mr. Ma Sharif. Please state your name.
Ma Sharif.
All right. Got two cases. What are we doing?
Judge, we're waiving both and we're
He's waiving up on both cases?
yes, Judge.
Sir, is that a correct statement? You're waiving your right to a preliminary examination?
Yes.
You understand that that is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
And you understand that you will not have those hearings in these cases and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Counsel, as to the circuit court arraignment, you acknowledge receipt of the information, waive its reading, and your client stands mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pre-trial in these matters will be set for
November 12th at 1:30 with Judge Conlon.
November 12th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Thank you. Bond will continue.
Have a good day.
You do the same, sir. Court calls the case of the people versus Jimmy Murray.
Please the court, I'm Roderick K. Green, P33837. On behalf of Mr. Murray, who stands to my left, good afternoon, Your Honor.
Good afternoon, sir.
Good afternoon, for the people.
Your name, sir? Jimmy Murray. Very good. And what are we doing on these cases?
Yep, we're asking for an exam on both cases, Your Honor. I believe I said for,
Do you have any objection if they're held on the same day?
beg pardon?
Do you have any objection if they're held on the same day?
Oh, no, not at all.
None of the people.
Is the 30th available, Your Honor?
Well, hold on a minute. See, this is what I'm talking about. That's how he is at church. Rushing people. The next thing you know, he puts that plate in front of you. Anyway, I'll talk about that. Okay. You have all of the discovery, is that correct, Mr. Green?
I do, Your Honor.
All right. But do people have their witnesses available on the 30th?
Yes, Your Honor.
All right. So yes, you were right.
Thank you very much, Your Honor.
All right. Preliminary examination will be set for September 30th. 2025 at 12 noon. Those are before me.
Thank you very much, Your Honor. Bond continue.
Yes, bond will continue.
Thank you very much.
Always a pleasure seeing you, sir.
Thank you, Your Honor.
Court calls the case of People versus Jamison Napier.
Jennifer Douglas.
And Wilson Tanner appearing with and on behalf of Jameson Napier, Your Honor.
Is your name, sir?
Napier.
Thank you. What are we doing?
We're setting this for exam.
Discovery is complete.
We're still working on investigation. Honestly, I'm still looking for a witness, but we can set it for if you.
Well, have the people given you all discovery? Because I'm not.
Yes,
Yes, Your Honor.
we have received discovery from them.
Would the people have their witnesses available on the 30th?
Your Honor, can I ask you for either the 14th or the 21st?
Do people have an objection to that?
No, Your Honor, no objection.
Preliminary examination in person will be set October 14th, 2025, 9 a.m. before Judge
Washington.
Judge Washington.
Thank you, Your Honor.
Bond
Hang on,
continue.
hang on. Thank you.
Court calls the case of the People versus Gary Coward.
Andrew Bannister, People.
Oh. I lost Mr. Burris showing.
Show up at 3, you know, why not?
Hey, whatever.
I couldn't miss it this morning. Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Gary Coward, standing on my right.
Your name?
Gary Coward, Your Honor.
Where's the rest of his pants?
What's that? You left him in the car.
Oh, next time you should wear them in.
I agree.
Okay, thank you.
I'll discuss it.
No, that's fine.
I couldn't think of a better answer. Your
I
Honor.
didn't know where they were. You're seeking an adjournment?
That's correct, Your Honor. 1 week should suffice if, unless, 2's fine, Judge.
That's not gonna happen. I have 1 or 3, counsel.
Okay. 3 is what date, Your Honor?
The 9th.
That's fine.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, sir.
Okay.
Court calls the case People versus Anthony Watson.
And good afternoon again, Your Honor. Please, Honorable Court, David Burgess on behalf of Anthony Watson.
Seriously? Wait, did you tell them, you told them do not wear full pants?
I didn't.
No,
I didn't.
Told Burgess that's 2 in a row. It hasn't happened with any other attorney.
When he was walking up.
In fact, I went through the whole PD office. It didn't happen.
Oh. I can, okay, sorry. So say I can loan him a pair, but you know.
Sorry.
Judge, we're requesting spam in this matter. Which time my client will have long pants on, Judge.
Yes, that they address appropriate.
Yeah.
So all discoveries complete.
That's correct, John.
People have their witnesses available the 30th.
I believe so, Your Honor. Thank you.
30th at 9, okay. All right.
Preliminary examination in person, September 30th, 2025. 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
Thank you.
Bond will continue. I think Burgess told him. I think you did. The people we came with, they got long pants on. How come? Never mind. Everybody just go home. Take care. Court calls the case. People versus Jacqueline Waitsel.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Wachel. We're appearing via Zoom this afternoon, Your Honor. That's with Ms. Wachel's consent.
All right. So Rachel, can you state your name, please?
Jacqueline Wachel.
Thank you. All right, what are we doing?
Your Honor, at this point, we've been before the court on a number of occasions, and I'm asking that the matter be set for preliminary examination.
And so you have all of your discovery, counsel?
I do, Your Honor.
All right. Would the people have their witnesses available on the 30th?
Yes, Your Honor.
Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is it 9? At noon. That will be before me.
Your Honor, I am going to indicate to the court. Actually, noon will be fine.
Okay.
I'm sorry, Judge. I apologize. I'm looking at my calendar.
No.
I'm trying to figure out what's
No,
going
that's
on
okay.
here.
So it'll be noon before me on the 30th. Thank you.
Very good. We'll see you then. Thank you.
Court calls the case of the people versus Keith Walker.
Jennifer Douglas for the people.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Mr. Walker. Mr. Walker, can you state your name for the court?
Keith Walker. Thank you. All right, what are we doing?
Judge, this is a date and time set for PCC. At this time, we would be asking for an adjournment. I am attempting to negotiate a resolution that would keep this matter at the district court level, and we need a bit more time to do so.
All right. Probable cause conference, I'll adjourn it to October 9th, 2025, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Judge.
Thank you. Take care. Been real. I don't know him. I do. Was he with something else? Another game? Did I lock him up? Should I have? Never mind. Court calls the case, people versus Devon Bob. I didn't.
590 standing in for attorney Monty Kavajian, P 76143, representing Devon Watson to my right.
All right, and you're stepping in his stead with his permission.
Absolutely.
Is that correct, sir?
Yes, sir.
All right. And you're requesting an adjournment?
Yes, we want to see if plea negotiations are successful.
Well, October 16th, give you enough time to get that done.
Absolutely.
Probable cause conference will be adjourned October 16th, 2025, 9 a.m. Bond continue. All right, thank you, sir.
Thank you.
And court recalls the case of the people versus Jeremiah Dillon. Why is? Oh, what do I do?
Good afternoon again, Your Honor. J. Grant Miller, P 58658 on behalf of Mr. Dillon, who stands to my right.
Jeremiah Dillon.
All right. I now have a plea form that indicates that the defendant would be pleading. Okay, I see how we did it. That the defendant would be pleading guilty to 2 charges. Count 2 of operating while intoxicated with an occupant less than 16, the 1-year offense. Count 4, controlled substance use of cocaine, also a 1-year offense. Upon the successful plea to counts 2 and 4, counts 1 and 3 would be dismissed. That is the court's full understanding of the agreement. Is that correct?
That's correct, Your Honor. That is the provision of the initial plea offer.
Correct.
That is defense's understanding as well, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Jeremiah Dillon.
All right. Sir, it is this court's understanding you're going to plead to 2 misdemeanor charges. First charge is that of operating with a minor in a motor vehicle or operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine, up to a $1,000 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
All right. And also on count 4, that you'll be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. You understand that, sir?
Yes, sir.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
We had checked the box, Your Honor. We didn't object to if Your Honor wanted to sentence Mr. Dillon. Thought we had appropriately marked the form.
Well, you put the form in the sentencing judge waiver, so this will be sent to Judge Washington. You understand that?
Yes, Your Honor.
All right.
It's fine.
Is that okay with you, sir?
Yes, sir.
He's not as familiar with the court system, sir. It's his first chance, and I explained it could be blind drawn, but he's had some time with Your Honor today, so he was just a little confused.
So you had time before me and still wanted to be here?
Yes, sir.
I see. I don't get that much. Okay.
Yes,
sir. All right. But this case will be sent over to Judge Washington. You understand that, sir?
All right, sir.
All right. Understanding all of that, do you still wish to plead guilty to these charges?
Oh, yes, sir.
All right. So to the charge of operating while intoxicated with an occupant less than 16, how do you plead?
Guilty.
To the charge of use of a controlled substance, that being cocaine, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, correct?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5 on that form. You'll see it on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Except community corrections, no, sir.
Okay, you're not under the
No,
jurisdiction
no,
of any other
No,
court.
no, no, sir.
He's in compliance with the terms of his bond, I believe is what he's trying to convey to the court, Your Honor.
Has anybody promised you anything other than
sir.
what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
August 8th, 2024, at the location of US 12, that being Michigan Avenue near Wired, in Ypsilanti Township, Washtenaw County, state of Michigan. Did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
All right. Had you ingested that cocaine and then operated a motor vehicle?
Yes, sir.
All right. And were you ultimately stopped by the police?
Yes, sir.
Why'd they stop you?
I think because my driving.
Okay, some erratic driving of some part?
Yeah.
Yes?
Yes, sir.
All right. You're not disputing the right of the police to stop you in this case, are you?
No, sir.
All right. And at that time, were you then arrested?
Yes, sir.
Were you taken to the hospital for a blood draw?
Yes, sir.
And did the results of that blood draw show the presence of cocaine and or its derivative?
Yes, sir.
Do you have any reason to dispute those blood test results?
No, sir.
And at the time of operating the motor vehicle, did you have, pleading to count 2, was there an individual under the age of 16 in your vehicle?
Yes, sir.
All right. Was there a Coda Dillon?
Yes, sir.
And how old is that person?
He's 5.
All right. Sir, if I accept your plea to this case and you commit misconduct as defined by the Michigan court rules from the time of my acceptance to the time of your sentencing, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that, sir?
Sir.
And you also understand, sir, that you would not be allowed to withdraw your plea.
Yes, sir.
All right. Is counsel aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
October 23rd at 10 a.m.
October 23rd, 2025, 10 a.m.
Yes.
10 a.m. before Judge Washington. Bond with its conditions will continue. And young man, I do appreciate you wanting to stay with me, but Judge Washington is a wonderful person and wonderful.
You're fine.
No, she's a wonderful judge and a wonderful person. You'll be just fine there. All right?
Your
Just
Honor.
do what she says.
No,
Because even I do that. Go ahead, what?
Just briefly, Your Honor, he has to go over to 14B
Yes.
for probation, and that is Ypsilanti
Ypsilanti Township.
Township.
Right.
Okay.
Not to be confused with 14A2, which is the city of Ypsilanti and part of our court.
Thank you.
That's over there off Whitaker, right? 14B, that's right.
Yes.
That's off Whitaker.
You're out that way.
Yeah.
Yes.
Out by the veteran.
14A is downtown on from Michigan Avenue.
Yeah.
Right.
Yeah.
Got it?
Yes, sir.
Okay.
Thank you.
Thanks.
Thank you, sir.
Take care of
Appreciate it.
yourself.
God bless.
And to you. All right, have anything else?